everyone. Welcome. Thank you for joining us for the OPA CPD Series, BDO Financial Wellness in the COVID Era. My name is Doug Taylor. I'm the chair of the Education Committee. I will be your facilitator for this evening. We are bringing this CPD webinar to you from Durham Region. I'd like to acknowledge that Durham Region is located on the traditional territory of the Mississaugas of Scugog Island First Nation. We thank the First Nations people who lived and live in these lands for sharing them with us in peace. Before we begin, we'll start with some housekeeping. Please kindly post any questions you have into the panel, into the Q&A panel. It's a little window at the bottom of your screen, your Zoom bar there, and we'll present your questions to the panel in the final segment of this evening's CPD presentation. I would ask that you kindly take a few minutes following this evening's presentation to complete the Education Committee's post-CPD survey. Your feedback helps the Education Committee improve on delivering valuable services to our membership. Following tonight's live presentation, we will also provide additional resources from the CPD on our learning and professional development portal at opau.ca. I will now introduce the panel. We are joined tonight by Ilan Kebel. Ilan is the Vice President of BDO Canada Limited, with over 20 years experience specializing in the consumer and small business practice, assisting both individuals and corporations in dealing with their financial situation. Ilan has a solid foundation in financial operations by applying a unique combination of audit, M&A, and due diligence expertise, offering the perspective required to oversee restructuring of both personal and corporate situations at multiple levels. Ilan's practice responsibilities cover the GTA, including Brampton, Etobicoke, Milton, Mississauga, North York, Oakville, and Toronto. We are also joined by John Zanis. As of March 2021, John was appointed as our paralegal member of the Justices of the Peace Review Council at the Ministry of the Attorney General. He is also the owner of Continental Legal Services PC, a firm that represents national and international corporate clients in litigation. John is the 2016 recipient of the LSO William J. Simpson Award and the past director and president of the Paralegal Society of Ontario and Ontario Paralegal Association from 2008 to 2014. He has always been involved in numerous committees and initiatives at the Law Society, including the Provincial Offences Advisory Committee, the Equity Advisory Group, the Treasurers Advisory Group, the Treasurers Liaison Group, and the Challenges by Racialized Licensees Working Group, just to name a few. John is active in the community, as community involvement also includes the Ontario Justice and Education Network, OGEN, the Library Information and Support Services Working Group, the Ministry of Consumer Services Amendment to the Collection Agencies Act Committee, and the Attorney General's Provincial Offences Advisory Committee. John has written many publications and articles over the years, including the submission to the September 2012 Attorney General on the 5-year review of paralegal regulation and the changes to the Bankruptcy and Insolvency Act for the U.S. National Association of Credit Management. On April the 15th, John was appointed to a 2-year term as a part-time member at the Landlord Tenant Board. John is also a director at Ontario Soccer and has been in that role since 2017. Also joining us this evening is our president, George Brown. When the paralegal profession became regulated in 2008, George became a member of the Law Society of Ontario as a paralegal licensee. George has been providing legal services since 1990, and over the years, he's developed considerable experience representing individuals and companies in a wide range of legal matters. Along with his practice, George is a member in good standing with the Law Society of Ontario. He's the founder and secretary of the Ontario Paralegal Network and former board member, secretary, and current president of the Ontario Paralegal Association. George is also the former board liaison for OPA's membership committee. George is an active contributor to the professional development of Ontario paralegals. He has taught and assisted in several continuing education courses and public information sessions for the Ontario Paralegal Network, Get Legal, hosted by Roger Dinner, Toronto Speaks, hosted by Natala Falcoma, and the Ontario Paralegal Association and the Law Society of Ontario. And so with that, I will now turn over the CPD to Ilan and the panelists. Perfect. Thank you so much. I'm just looking at the clock. I'm going to try and squeeze in. We've got a ton of questions, so I'll just try and get through them as quick as I can here. Thank you, Alain, John, and George. So let's move to the question and answer now. First question comes from Mark. Can we now represent clients in bankruptcy proceedings and or proposals for debt payments, etc.?
So from my experience, no, I don't. You cannot. I think you've got to be a lawyer to represent the client, or the client can represent themselves.
Okay, next question comes from
I
Donald.
agree.
Go ahead, George.
I'm just saying that I agree that a paralegal is outside of the scope.
Okay, thank you. Next question is from Donald. Can debts not disclosed by the debtor be pursued by that creditor after the bankruptcy is discharged?
So typically, I would say no, because if the debt was relating to prior to the bankruptcy, once the bankruptcy is discharged, the debt's also discharged. So if an individual becomes aware that they weren't notified, they should get that debt registered and then to start taking their action, as I say, if they think it's fraud, to get that uncovered. But no, after the fact, we would just send out a notice saying this was part of the bankruptcy, it's a pre-bankruptcy or proposal debt, and therefore it's stopped by the process.
Okay, great. Thank you. Next question comes from Rob. If one partner of a partnership claims personal insolvency and the partnership agreement is silent, what does that mean? Or does that mean, there is no legal recourse against their portion of the partnership? Since there is no separate legal structure, does enforcement against the partnership become void because one partner's personal insolvency?
So I think what I think I'm trying to understand the question, and I think what we're saying here is, if there are debts that have been incurred by the partnership and there are partnership debts, then you're both jointly and severally liable for those debts. If it's an individual partner's, like personal debts, other than if there's a value in that partnership, which we would value at the time of filing, that value or that asset would be reported as that individual partner's asset in his personal insolvency.
But here's what I think he's asking that question is, if there's no partnership agreement that said that it's 50-50 or 70-30, can this creditor get all of it because there's no partnership agreement? I guess they could.
I would maybe, and I'm not a lawyer, and if I was a lawyer, I'd maybe argue if there's a verbal agreement that it's 70-30, I would argue as a lawyer that that's an agreement. If they both concur, they're both willing to say it's 70-30, then I would think, yeah, it's a 70-30 partnership. But it would be difficult that would become a bit of a legal battle, and who knows who's going to win that one.
Elon, have you come across a situation where somebody had a house and they said they only own that house 10% of the house, and the other person's got 90%, and they put this execution on the property? Is it full on for both, or is it just that 10%, for example?
Well, your execution is generally registered against the individual, right?
Yeah, and let's say both of them own the house, but that person's only put 10% of and they've got an agreement saying you're putting your money in, you only own 10% of the house, 90% is mine, that kind of a thing.
Well, we look at how it's registered on the Land Title Act. So you can have whatever agreement you want. If it's registered at that amount, then yeah, then it's 10%. If you're registered 50-50, but you wrote agreement that it's 90-10, we look at the land registry and we go with what's registered on that property.
Yep.
Okay, next question comes from Susan. What happens to funds in a general funds account if a paralegal claims insolvency? Is that money included in the total assets?
I would say yes. It's like any other general bank account. It's the business's asset, right? What's the paralegal's really money as opposed to the trust fund money. So yes, that would be. So if you start segregating trust funds in your general account, chances are the trustee is going to assume those funds.
Okay, great. Thank you. Next question comes from Sandy. What happens to seized funds that were garnished from a bank account and are sitting in court if a debtor claims insolvency? Does the court send the funds to the trustee?
So I think there's been multiple ways that this has happened, and I think it would be ultimately how the court would determine at that point in time. And the trustee would go to court to argue that those funds should be funds available to the estate. However, the other party, I assume, would relay arguments why it should be their funds, and at that point, it's going to be determined by the judge at that point in time. So there's no real cookie cutter answer that yes, it's 100% going to come to the trustee.
Okay, perfect. Next question comes from Brian. I was once dealing with a judgment debtor that went to debt counseling company. The debt counseling company called and offered 60 cents on the dollar to settle in full. I declined because I had worked out a monthly payment plan with the debtor on the judgment. I was told by the company that this was a one-time offer and that if I refused to accept, they would move on to the next creditor and offer them a payout. Seems very arbitrary to me. Is this fair practice? Are there any rules around, for example, the largest creditors getting the first offer for settlement before moving to the smaller creditors?
So no, there's no rules around this, and it's basically experience on these are informal settlements and coming up with an arbitrary number and saying what you're going to offer. You typically, what you find is they would typically chip away at the smaller creditors first, because a small dollar amount to a smaller creditor is easier to settle on. It's more personal to them, and then that start working their way through to the larger creditors. So it is arbitrary, and basically based on the experience, who's easier to negotiate with, get those little wins, and they want to negotiate initially a small amount as possible, because the more they keep in the end is more what they get to keep for their costs and fees.
Okay, great. Thank you. I'll try and squeeze a couple more in here. This from Candace. If I know that a client obtained property or services fraudulently, since this is a criminal offense, do I have a duty to breach my client confidentiality and inform the creditor, trustee, or debt counselor?
I, once again, not a lawyer, and I'm going to defer this a little bit to John and to George, but I would say, my gut would say you would have to be very careful breaching your client confidentiality. I believe there's maybe circumstances where you have to, and that was if you're ordered to by court, or if there's some kind of other criminal investigation going on. Other than that, I would sort of defer that to John and George or to a lawyer, whether you can do that or not.
I would elect to simply withdraw services.
Okay, great. Excellent. Thank you. Next question comes from Amina. What can I do if a small claims court judge refuses to take 100% of the debtor's entire assets to give to my client?
I once counted the number of times that the word may was utilized in Section 20 of the Small Claims Court rules, and I believe it was 51 times. So that tells me that the enforcement provision under the Small Claims Court is absolutely discretionary. I don't think you can fight a judge who is going to exercise his discretion that he's not giving you 100%. I don't think you would win at all. I think the court has the power to do that.
I would assume you could appeal it, but now you're going to ask yourself, are you going to spend that kind of cost to appeal a small claims decision? I could be wrong, but I think you could be spending a lot more money to go after something that's not even recoverable, maybe. I don't know.
I think the decision might also be considered interlocutory, so it's not appealable.
Okay.
Okay, great. Thank you. I'm going to squeeze in one more because we're almost at 9. This is from Cheryl. How would you handle when factoring a company buys an invoice, trucking company goes bankrupt, and you manage to collect the money for the invoice that belongs to the factoring company? Do you keep the funds or do you give them to the factoring company?
Sorry, I'm just processing. So as a trustee, that's really going to be, once again comes into, is there a general security agreement in place? So if there's a general security agreement in place and that factoring company has security on those receivables, then it's technically their money and we'd have to hand it over to them.
Yeah, I mentioned earlier about that situation where we represented a client and we knew the company was closing down or doing something the next day. we had a check. We went and we got the check certified that on the eve of what was going to occur. Now, somebody could have said, when we got this certified check, you didn't do this in the ordinary course of business, but we had done our research, and it was in the ordinary course. It was a deal we had done months before. So it wasn't like we snuck that money out of their account. It was a check. So I think if it was a factoring company and you got a deal done and you collected the money, it depends on when it occurred. I think it could be clawed back 30 days, within 30 days of the bankruptcy. It could be an arguable issue. If it was 60 days before, 60 days after or before the bankruptcy, I think you would have less of an argument there. Elon, am I right?
Yeah, I mean, the typical answer we get, because you say, is it in the ordinary course? And, if you're paying your creditors typically 30, 60 days, that's your ordinary course. But the answer we get from a lot of these companies that maybe get paid a big chunk of change just before the bankruptcy, in your heart of heart that they've done it because the owner had a relationship with this company. But the company's answer to us is, just because I'm astute and I'm claiming I pursued them and I put pressure on the company and I got them to write me a check for the money they owed me, all I was doing was collecting what they owed me. So it's not that I was out of the ordinary course. I was owed that money and I was the more aggressive creditor and I got paid. And it's hard to argue against that. So there's two different things here. If they collected in time and done it, arguing whether it's in the ordinary course or not. But the other thing, if it's a factoring company, you've got to, and they don't have a general security agreement or security over the receivables, then the trustee would hold on to that money. If they hold it, they're a secured creditor, they're entitled to the funds.
Yeah, and just because you heard that a company went bankrupt doesn't mean you have to give it to the trustee, unless you've got some kind of a letter from the trustee saying, hey, do you have anything that's owing to this company? Give it to us. You would normally just pay your client, take your fees out or whatever was required. You're not bound to be a good Samaritan and saying, hey, trustee, I've got this money that belongs to this company, and should I give you this money? Like, that's not really. I don't think that's something that is required for somebody to do, is to make that inquiry. Is it owed to you? Am I right, Elon? Or
yeah, I think comes back to the dollar amount we're talking about. We're talking about big dollar amount, and it's the factoring companies out of sorts. You may have a lot of legal letters coming your way saying, hey, these were our funds, we were secured, give us the money. If it's not a large amount, then it may not be. It may be an arbitrary thing, and they may just overlook it and move on to the next debt. But factoring companies are typically going to move pretty quickly when they realize they're not getting paid.
Yeah.
And we also have to consider the client as well, that if the client doesn't want you to contact the trustee and disclose that, you can't.
Perfect. Thank you. So on behalf of the OPA, thank you, Alain, John, and George, for taking time away from your families this evening to join us and share your expertise. All of our panelists have graciously offered to extend themselves for this evening's CPD. So if your question was unanswered or you have any follow-up questions, we will provide their contact information in our post-CPD resources at opau.ca. This concludes this evening's OPA CPD Series presentation, BDO Financial Wellness in the COVID Era. Thank you to all our members for their participation.